Hi, I'm going to talk to you today about what happens when your child turns 18. We get asked this question often, and I want to provide some guidance to you. So up until your child is 18, you are able to make all decisions for them. Medical decisions, financial decisions, and of course, legal decisions. But when your child turns 18, they are legally emancipated. We all understand that they may not be emotionally emancipated. We certainly understand that they're not financially emancipated. But by law, at 18, they are legally emancipated. So, if your child does not have the capacity to make these kinds of decisions, you need to determine whether or not they can execute a power of attorney, both a healthcare power of attorney and a financial power of attorney, or do you need to file for guardianship or conservatorship? And I'm going to guide you through this process. The first part I want to talk to you about is our powers of attorney and what are they? They are legal documents, both that handle and deal with your finances and your healthcare decisions. Financial power of attorney can have agents in which you can appoint them to make decisions with you and for you. You do not give up your rights to make these decisions. You're just adding somebody on to do them with you. The financial power of attorney should be comprehensive enough that you are able to handle any situation that may arise in the area of finances, from gifting, paying taxes, doing banking, setting up trusts, Medicaid planning, real estate transactions. These are all incorporated into a financial power of attorney. A healthcare power of attorney deals with your health. You are appointing someone when you no longer have the capacity to make decisions for you. Speak to doctors, access your medical records, and then also has a combined directive where you're deciding upon advanced life measures. The financial power of attorney should be durable in that it stays in effect when you no longer have capacity. Financial powers of attorney can be immediate, where they're in effect at the time that you sign them, or they can be springing, where they come into effect upon a certain event or act. Who should have one? Everyone over the age of 18 should have one. The issue when it comes time for a special needs child is whether or not they have the capacity to execute one. Do they understand ramifications of their finances? Do they understand money? Would they understand that they would need a surgery or blood work? And therefore, do they need a healthcare power of attorney? And if they can't execute a healthcare power of attorney so that somebody else is able to make those decisions, do you need a guardianship? A healthcare directive, and we do a combined healthcare proxy or power of attorney with an advance directive or instructive directive, which is a living will, in which we appoint someone to make those medical decisions for you. Again, this comes into play when you no longer are able to make your own decisions. It's important to remember that you have the fundamental right to make your own medical decisions until you are no longer able to. And the same goes for your children. So what happens if your child, you feel that they understand finances and they understand health? Well, they can execute powers of attorney naming the parent as their agent under the power of attorney. If they do not understand those ramifications because you are not taking away their ability to do it, and you are concerned that they need complete guidance, you would now need to think about filing a guardianship. A guardianship comes with an adult coming of age, a child, 18, and it also comes about when we have a senior that loses capacity and that did not have a financial or healthcare power of attorney in place, or their health or financial power of attorney was not comprehensive enough in order for them to accomplish the goals that they needed. Let's talk about the guardianship process. and what it entails. We usually begin the guardianship process several months before your child turns 18, so that at the time that they turn 18, we will have a hearing date in court. The reason we want to do this is because if you have a gap of time that your child is not covered by a guardianship, and that child does not understand medical and financial ramifications or decision making, there isn't anyone that is able to make those decisions during that time. For example, if your child takes certain medications and there's blood work that needs to be done, and they turn 18 and they go to have the blood work done, and you have not filed for guardianship yet, and there's no letters of guardianship, which is the certificate that entitles you to make these decisions, and they turn to the phlebotomist and they said, I'm not going to give blood, the phlebotomist is going to have to say, I can't take the blood from the child. And the reason is because over 18, that child, if the child says no, they have to listen to them. They have to listen to you if you have been formally appointed that child's guardian. So let's talk about the process. It's not overwhelming. We take people through it step by step, but there is planning that it needs to take place. We need 2 exams conducted within 30 days of filing for the guardianship. The exams are done either by a physician or a psychologist. You can have one physician, you can have a psychologist, you can have 2 psychologists. There is a certification that the psychologist and or physician must complete. The exam has to be done within 30 days of filing for the guardianship. The reason for that is that the court wants to know that the medical status of the child turning 18 is most recent and that they are not being evaluated from a prior situation. I normally get appointed by the parents to represent them as the proposed guardians, and the court will appoint an attorney to represent the child or the proposed ward. The court does this in order to protect the ward or the child, because there could be a conflict of interest in that the parents are bringing a guardianship action for reasons that are not in the child's best interest. Now, we often don't see that, but the court still has to protect the child coming of 18 or a senior that is having someone file for guardianship. There is a court appearance that's necessary. Sometimes with my guardianships of children turning 18, the court will allow the guardianship hearing to be conducted on the telephone, and everyone can stay in their own homes or meet in my office. And sometimes the court will actually decide the action on the papers, meaning there is no appearance necessary in court and there is no telephonic hearing. Once somebody is appointed guardian, and after the hearing takes place, there's some paperwork that has to be completed, and then the guardians receive what are called letters of guardianship or guardianship certificates. And those certificates allows the guardian or guardians to now make financial and or health decisions for the child. A guardianship is over the person and the estate. Now, you can have what's called a limited guardianship. And what's a limited guardianship? Well, if you want to carve out certain rights for your child that turns 18 or certain decision-making rights, you can do that. They can have vocational decision-making. They could have financial decision-making. They can have residential decision-making. We carve out the ability for them to drive if you want to, for them to vote. Maybe you want them to be able to bank up to a certain amount of money. These are all things that we can do based upon a dialogue that we have and based upon each person's situation. If you feel that your child does not need to have a guardianship because they will understand medical ramifications, but you are not sure that your child understands finances, you can file a conservatorship. A conservatorship is where you are making decisions for a person but it's only over their finances. It does not involve any decision making with regard to their health. So if that's important in terms of decision making for health, placement into residential facilities, any kind of medical decision making, you would need a guardianship. A conservatorship is only over property and finances. Sometimes I've had a situation where a child was compliant, was functioning enough to be able to understand medical ramifications, but had a trust fund, and the parents were concerned that the child would get a credit card or would be subject to a scam and fall privy to that. And so we look to avoid those problems, and we have a conservatorship put into place. We also have seniors that lose their cognitive abilities, and they may get taken advantage of, and so we also look to put into place a conservatorship. A conservatorship is voluntary, and you do not need a declaration of incapacity by two physicians or a physician or a psychologist. That is a voluntary act, and it can be undone. It can be brought by another person on behalf of another person, but it is a voluntary act. A conservatorship is also filed a complaint. You do sometimes have to have an appearance in court. Sometimes it can be done also on the papers. It all depends on the judge. It all depends on the county that you're filing the conservatorship in. Now I'm going to talk a little bit about some estate planning mistakes when you have a child with special needs. We often have people ask us, what should they do, or what happens when they die if they have a special needs child? And there are some common misconceptions that people have. One of which is, should I just disinherit my child? Because they will be on government benefits, and if they come into my money, they would lose their government benefits, so should I just disinherit them? And the answer to that question is, they're likely going to need your money, sometimes more than your children that do not have special needs, because they can hold jobs for many years. And so disinheriting is not necessary as long as you have your money going into what we call a special needs trust. Another misconception or an estate planning mistake that we see is leaving a greater share to one of your children to take care of another child. The concern that we have with this is that if something happens to your child that does not have special needs, if they file for bankruptcy, if they get divorced, the money that you earmarked for that child will not be there. And we have seen these situations arise, and so we don't ever recommend leaving a greater amount of money to one. There also is a tremendous amount of responsibility and burden placed on the non-special needs child. Again, the better way to do it would be to set up a special needs trust. The sibling can be a trustee or an alternate trustee after you, but they don't have the money in their hands that it could be jeopardized. Another mistake is leaving the money directly to a child with special needs. If you do, and that child is on a government need-based benefit, such as SSI or Medicaid, they will lose it, and they will have to come off the benefit and spend that money down and go back on the benefit. The better option is to have your money go into a special needs trust. They can remain on the government benefit, sort of the best of both worlds, and still have your money to enhance the quality of their life. Another mistake is leaving your assets to your special needs child in what we call a general needs trust or a minor trust. So most of our clients don't want their children to come into their assets upon turning 18 because, as we all know, children these days at 18, although legally emancipated, are not necessarily financially or emotionally emancipated and understand how to spend the kind of assets that a child can be coming into. And so we often see that parents put assets into a general needs trust or a minor trust in which their children will receive their money at certain ages. For example, 1/3 of their estate at 23, maybe followed by half of the estate of their share at 26, follow the remainder at 30. That's an example of a minor trust. But if you leave your assets to your special needs child in a minor trust, even though that will guide when the child can receive the money upon ages, it will not protect those assets for government need-based benefits. In essence, the general needs trust or the minor trust is not protective of the child keeping their benefits like a special needs trust. So sometimes when we're doing estate planning for our clients, and they have more than one child, we will set up a minor trust for the children that do not have any special needs, and we will make sure that we have a special needs trust for those children that have special needs. And that way, the child that has special needs will not lose their government benefits. There are two kinds of special needs trusts. There's a first-party special needs trust and a third-party special needs trust. A first-party special needs trust is funded with a disabled person's own money. So if they had a personal injury settlement and they come into money, they would be taking that money and putting it into a first-party special needs trust. It's their money. If they have back money from a Social Security claim, again, they come into a lump sum of money and they want to put that into a special needs trust. It would be a first party because it is the proceeds or the funds of the special needs person themselves, and therefore it's a first party special needs trust. A third party special needs trust is funded with someone else's money. And these are the kinds of trusts that we set up with our parents. The money is never going to be directly the child's. It's going to come directly from you, and therefore it's considered a third-party special needs trust. I indicated why we have a first-party special needs trust. Sometimes we have a personal injury medical malpractice award, an inheritance received outright, or the parents put it into a minor trust, and now we have to move it into a first-party special needs trust. The only problem is with a first-party special needs trust is that upon the death of the child or the person that had the special needs trust, the money that is still left in the trust will go back to the government. There's a lien on any unused portion of the trust if the government has paid out in government need-based benefits. A third-party special needs trust does not have a payback provision. There is no lien that the government will assert because it was your money, and therefore in our third-party special needs trust, you can designate who the money goes to. So if you have other children, we would designate in there that the children, your other children, receive the proceeds of that special needs trust upon the death of the special needs child. A third-party special needs trust can be funded through your assets that you've accumulated. It can be funded through a life insurance policy. You can make an IRA, the beneficiary, be the special needs trust. And we work with our clients on making sure that when we're doing estate planning, that the assets that pass under their will are directed to the special needs trust, and the assets that pass through contract designations or beneficiary designations, like life insurance policies or IRA or 401k beneficiaries, reference the special needs trust as well, because not all assets pass under the will. In addition, a third-party standalone special needs trust can be funded by other people. A grandparent can refer to a special needs trust, and again, we can have the contract assets such as life insurance or IRA or 401k policies refer to the special needs trust. How does a special needs trust work? There is statutory language that must be in the trust in order for it to be compliant. If there is certain language in the trust and the funds are spent in an appropriate manner, then the person that is on a government need-based benefit can remain on that benefit and still pay for aspects of their life that are not covered by the government need-based benefits. There are certain requirements that must be met, and there are stipulations on how the trust is to be utilized. In general, anything that the government is providing for, such as food, shelter, utilities, real estate taxes, rent, mortgage, those kinds of things, you can't use a special needs trust for. Your government benefits will be impacted for the month that you are utilizing that benefit. But a special needs trust can pay for a lot of items that are not covered by the government benefit. Housing, such as telephone, cable, furniture, cleaning supplies, medical insurance premiums, co-payments, wheelchairs, scooter, eyeglasses, dental treatment. You can have recreational expenses paid by the special needs trust, club memberships, TVs, computers, vacation and travel. These are all things that a special needs trust can pay for, and the person can still be on government need-based benefits. You can utilize a special needs trust to pay for a car, gas, insurance, maintenance, and repairs. Again, there are a lot of options for a special needs trust, and they are an amazing tool for your child to enhance the quality of their life and still remain on government need-based benefits. There are a lot of questions that come up when your child turns 18, and we are here to navigate you through that process.